the December meeting of the California Law Revision Commission will come to order. A quorum is present. And first order of business is the approval of the minutes from the November meeting. Are there any?
To adopt the minutes.
There's been a motion to approve. Any comments or corrections? Hearing none, seeing none. Is there a second to the motion?
I'll second it.
Jane seconds it. Brian, want to call the roll?
Yes. Commissioner Carrillo,
Aye.
Commissioner Cubas,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye. Minutes are approved. And Anna wanted to congratulate you on your reappointment. So we're good. Glad
Thank you. Thank you very much. It's an honor to serve, and I look forward to many more years.
Excellent. Next item is the executive director's report.
Yeah, and I don't have much to report this time. One was I was going to mention that Commissioner Cubas had been reappointed, and the other two vacancies that were left by the end of Commissioner Milo O'Brien and Rubin's terms have not yet been filled. So we're running a little light. We do have a quorum today, but Commissioner Jenkins could not make today's meeting. The only other item to report is that our companion agency, the Committee on Revision of the Penal Code, released its annual report today. And so after the meeting, I will email a link to commissioners. So if you're curious to see what they're up to, you can.
Okay.
That's all I have for that item.
Okay. Great. Thank you, Brian. Before we move to the next item, there's something I needed to share with you. 11 days ago was the 15th anniversary of Brian's appointment as executive director for this body. To put that in perspective, 15 years is longer than anybody can serve in the California legislature. 15 years is longer than Willie Brown was Speaker of the Assembly. 15 years was almost as long as Jerry Brown served as California governor. And as I'm sure all of us have observed, Brian's deep understanding of California laws, his incredible ability to describe complex statutory structures in an understandable way that even non-lawyers like me and Anna can understand and make informed decisions. His good humor, his thoughtful management have all helped make this commission both a very respected organization as well as a valuable resource for the legislature, the governor, all the governmental and non-governmental organizations that rely on our expertise. So with all that said, I think now Kristen is going to share with everyone a memento that staff has prepared for Brian to commemorate this occasion. It's a small token of the respect and the affection that we all have for him.
Yay, Brian.
Thank you, Rick.
Kristen?
Brian, you're going to need to give me access to screen sharing, Brian.
Okay.
If that's possible. Rather than trying to show these live, we've determined that it's better to show a picture because it's a little challenging to try to do it over Zoom.
You've got it now, Kristen.
Okay, thank you. So hopefully now
There we are.
we have some beautiful bookends. They say Brian Hebert, Executive Director, California Law Revision, for 15 years of outstanding leadership.
Wow.
So there they are. Brian, I'll be getting those to you in person shortly, but just to give you a little preview of what they are, and we really appreciate all of the years you've put in. So
Thank you. I honestly had not noted the date, so I'm surprised. Congratulations. And I hope, Rick, that your recital of all the folks whose terms I've exceeded wasn't a suggestion that the commission should have term limits.
No, I'm
No.
opposed to term limits.
Okay.
Term limits are an insult to the voters because it's the rest of the state telling you you're too stupid to decide who you want to represent you. That's mine.
Well, that's really kind. I appreciate it. Thank you, everyone. I wasn't expecting it.
Great.
I look forward to seeing you, Kristen, in person for no other reason than just to get together too.
hopefully we can find a time maybe next week.
All right. Okay. moving on, commissioner suggestions, any suggestions by any of the members for issues to take up? Hearing none, seeing none. Annual report.
Hey, good morning, everyone. This is memorandum 2021-60. I think most, if not all of you, have seen the annual report before. It doesn't change too much from year to year. It's just updated. We have just a couple things to ask you about. There is, first of all, as indicated in the memo, there's some contingent text which is shaded. This has to do with the commission's work in the next year. We report to the legislature what we're intending to work on. And in some of those instances, the commission has not yet made decisions. We're going to have presentation of the new topics memo at the next meeting in January. And the decisions the commission makes at that meeting on that matter will then be incorporated here in the annual report before it's finalized. There is a section which we'd like to update each year relating to the activities of the commission members and staff. If anyone has anything that they would like to submit, they can. It would be better to get it in writing rather than let me know now orally. But if you can let me know orally whether you have anything that needed to go in there, I can direct you to the page. I believe it's page 30.
Anybody have anything for Steve to add at this time?
Okay.
Steve, I guess, I don't know if it's a question or a point. I'm looking at the footnotes, and to my everlasting joy, I note that the date is in the middle of the case citations.
Yes. Did I still not? Is there still something that says?
No. So number one, I just want to note that had occurred, but I was just wondering, are we just doing that sub silentio, or is that noted somewhere in this memo and I didn't observe that we're switching formats?
It's not noted in the memo.
Okay, good.
Is that fine? I don't know.
Yeah,
if
that's
anybody
fine.
has any thought about that?
No.
Yeah, when we had discussed it before, I think the idea was that we would start doing it as soon as we were preparing materials for the next distinct volume. Of it.
Yeah. I remember that. That's correct.
So that's where we are.
Okay, and the same is true in the annual report as well. Or maybe that's what you were referring to exactly.
Right.
All the footnotes, etc. So okay, so no activities to report. If anyone thinks of anything, they can let me know. And then the other thing that we needed to know about is, well, I guess two things. You have a bio appendix, which is part of the annual report each year, and I've submitted you a draft copy. Anyone have any? I received from Commissioner Simpson, I received some requested changes, which will be incorporated again in the final version of the annual report. Anyone else?
I have one minor thing. I always use a middle initial because there's literally 450 guys named David Carrillo in the United States.
Okay.
So looking at the staff draft annual report on page 25, I would add my middle initial A. And anywhere else it appears. So like if it's not in my bio, which I'm not looking at right now, if that's not a huge deal.
No, it's not a deal at all. Okay, I will do that.
Thank you.
Anything else for anyone? Okay, you can let me know, send me an email if there is something. And then we ask every year if anyone has any editorial suggestions relating to just the presentation of the annual report generally and its composition. Anything?
Any suggestions or edits by anybody? Seeing none, hearing none? Okay,
Okay, well,
Yeah.
that's fine.
that's not something, is that something we need to vote on, or?
Yes, it is a report to the legislature. Actually, Brian, I don't know, should we have, I guess the administrative, the stuff that we're going to fix at the end will afterwards is as administrative. So yes, I would say we need a vote, roll call vote on a final report here, and I will just go in order of the.
We could make express the fact that what you're approving is the report subject to technical adjustments to
Right.
reflect the decisions that are made in January about work for 2022.
Got it. Okay.
Okay, so
Call
I'll
roll.
do a roll call vote, just in order of the windows I see here. Commissioner Simpson,
Aye.
Commissioner Carrillo,
Aye.
Commissioner McAllister,
Aye.
Commissioner Kubas,
Aye.
and Commissioner King. Excellent.
Okay.
Okay, thank you very
That is
much.
approved. Thank you, Steve. The 2022 legislative program, Brian?
Yes, this is memo 2021-61. And all I'm doing in that memo is providing you with sort of a preview of what's coming. No bills have yet been introduced, but the memo runs down the different recommendations and other conforming changes that we're going to be seeking authors for. And I do not yet have sufficiently firm commitments to talk publicly about who might serve as an author, but the work is proceeding well, and I don't foresee any problem having authors for the introduction of those proposals.
Great. Okay. Any comments or questions from members? Seeing none, hearing none. Item 4, stock co-ops, et cetera, Brian?
Et cetera. Thank you.
Et cetera.
Memo 2162 and its first supplement.
Mhm.
This continues a discussion that we had at the last meeting of the revocable transfer on death deed statute and how it relates to stock co-ops. And at the last meeting, I originally presented a draft of a recommendation, but then later proposed that you not approve it yet, because I saw a new issue that required further discussion. And I said that I would bring it back for the discussion at this meeting. And that's what the main memo is it's just a very simple recap of what the issue is. And then because I had sufficient time before this meeting, I prepared the supplement, which gives you proposed implementing language for the 3 different alternative approaches that are described in the main memo. So if you decide today that you're comfortable choosing one of those alternatives, you could approve the recommendation that's again attached to the supplement as modified by the language set that corresponds to the alternative you've chosen. Subject again to any other changes that you want to make at this time. The issue hasn't changed. It's the same that we discussed at the last meeting. It has to do with the treatment of interests in property that are where that property is then transferred by revocable transfer on death deed, and what effect that transfer by RTOD deed has on these prior interests in the property. And the original RTOD deed statute has probate code section 5652B, which requires that any interests in the transferred property be of record in order for them to continue to be enforceable against the property. And the thing that prompted this whole discussion at the last meeting was my unease with that strict rule being applied to the kinds of very important and typically off-record restrictions that exist in stock co-ops, age restrictions, a right to repurchase, a right to approve occupants, things that are sort of really close to the essence of stock co-ops. And so my original thought on that was we ought not to enact a statute that has any possibility of defeating those kinds of restrictions in a stock co-op. And so my original proposal was we should carve out an exception for them from 5652B. And when I was preparing the memo for the last meeting, I wanted to make sure I understood better, like what were the implications of that? Because you know, that strict approach originally, when the commission recommended the original RTOD deed statute, that strict approach was considered to be important because it provided that anything that's enforceable against the transferred property is in the record. And that facilitates the issuance of title insurance, which in turn facilitates marketability of the property after the transfer. And so I wanted to make sure I understood how that works. So I went back and did a survey of the law on unrecorded interests in property and their enforceability. And what I found was reasons why I thought maybe it wouldn't be a problem to create this exception. And specifically what I found was that the standard title insurance policies do not cover off-record interests in property that are ascertainable through inspection or inquiry. So they're already carving out that class of off-record interests from the scope of their coverage. They're not insuring against those things. So if they're ascertainable, then the title insurers should have no problem with the potential enforcement of these off-record interests. And then on the reverse side of the coin, I wanted to think, well, what's the implication then for the purchaser or encumbrancer downstream who acquires a new interest in this property and then discovers that there's this off-record interest that the law would preserve the enforcement of? And what I found was that an essential element of being what's called a bona fide purchaser for value or encumbrancer for value, because this doctrine does not apply to gifts. You have to actually buy your interest. An essential element of that was that in order to be a BFP, you can't have notice of the interest that you're trying to avoid. If you have notice of that interest, it binds you. And so you've got, like I said, two sides of a coin. On one side of the coin, if the off-record interest is ascertainable, the title insurers are disclaiming it. They're saying we don't cover that. If it's not ascertainable, then it doesn't bind the purchaser or encumbrancer. If their duty of inquiry couldn't have turned it up, then it's no longer enforceable against them. So either of those two possible situations produce a result where the title insurers are not going to be required to indemnify. So it looked to me like the general law was sufficiently nuanced to avoid any problem for title insurers or BFPs. And so that's what I discussed at the last meeting. And then I also discussed the fact that once I saw it through that understanding, it became unclear to me why we had this restriction at all for any kind of property, not just for stock co-ops. Because 5652B is stricter than general law in a couple of important ways. One is it sets a hard deadline for recordation. There is no such deadline in general law. Under general law, all you have to do is record your interest before there's a subsequent interest acquired by a purchaser or encumbrancer in order to bind that person. Well, I should say, yeah, record it before. So under existing law, it has to be of record at the time of the transferor's death. Under our proposed amendment, which is going into effect in January, you've got 120 days. But so if you miss that 120-day window, you're out of luck. You're no longer enforceable, even if you record before anybody acquires a subsequent interest. So that's stricter than existing law. The other way that it's stricter is, as I mentioned, even if you didn't record before the subsequent purchase or encumbrance, if that person actually knows about your interest, they're bound by it. So they can be bound by it even if it's never recorded. And so 5652 requiring recordation and requiring that it be within a certain time frame is significantly stricter than general law. And I was wondering, well, why is that required? You know, given what I described as my understanding of how general law operates, title insurers shouldn't have any more problem with a revocable transfer on death deed resulting in an off-record interest being enforceable than they do with any other kind of transfer. So, for example, during life, I decide to take out a second mortgage against my house. If I've got an off-record interest, The encumbrancer is potentially going to be subject to that if they have notice of it, or if it's recorded before they record their interest. And that would be the same result if I had acquired the property by revocable transfer on death deed. So I thought we should kick this over to December, invite further input from the California Land Title Association, and see what you thought after we'd had a chance to receive that input and talk about it further. And I invited CLTA. I see at least one name I don't recognize. So if there's anyone here from CLTA, could you raise your hand, please? Yeah, I thought not. I reached out to them 2-3 times, and unfortunately they didn't commit to come, and apparently they're not here, nor did they give me any kind of written feedback on the issues in the memo. So we don't have any more information beyond the analysis that I did, which I've sort of re-upped in preparing the memos for this meeting. So the question before the commission is whether you feel ready to recommend a change to 5652. And there are 3 alternatives that are set out. One is very narrow. You just make an exception for stock co-ops. The other 2 are essentially the same, which is modifying 5652B so that it removes the special recordation requirement in reliance on general law. And there are 2 variants of that. One is just silence, just delete the special requirement. The other is to replace the special requirement with an express disclaimer in the statute saying effectively that, well, let me see what the language says, hold on. Rather than paraphrasing it. The transfer of property by revocable transfer on death deed has no effect on an interest in the property that existed at the time of the transferor's death. So it's just, it's inconsequential to the effect of that pre-existing interest. And you just, as the comment would make clear, that you then turn to existing law. The comment says, Subdivision B of section 5652 is amended to delete a requirement that an interest in real property be recorded in order to remain enforceable after a transfer of that property by revocable transfer on death deed. It was replaced with an express statement that a transfer of property by revocable transfer on death deed has no effect on such an interest. This means that the priority, validity, and effect of the interest is governed by general law, and then there's a string cite to different authorities. So those are the alternatives that were presented. The just carve out an exception for stock co-op interests, or remove the requirement for any kind of property and either replace it with silence on the issue and an annotation in the comment, or this express disclaimer language and an annotation in the comment. I was contacted by John Anderson of Texcom. He wasn't able to attend today, but he let me know that he personally, not speaking on behalf of Texcom because they haven't had an opportunity to meet and make an entity decision, but he personally prefers the third alternative, the express disclaimer. So we do have some people in the audience. I can answer any questions you have. Or if there are people who are going to want to be heard on this item, if you could raise your hand.
Right.
Ryan, question?
Yeah, David.
Sorry, so the one of these options that John Anderson prefers is number 2 on page 5. Is that right? Express disclaimer.
Yes. Sorry, I was reading from the language in the supplement, so I was on a different page, but
Right.
That sounds correct. Let me confirm it.
It is, yeah.
Okay.
Thank you.
So does anyone have any questions for me? I don't see anyone in the audience who wants to speak to this.
Jane.
I think I'm kind of loath to move forward. I really would love to hear from the land title to see what the real world applications would be of anything that we do going forward. I mean, at this point, I would lean the same way as Texcom as far as the disclaimer, because I think it's the safest in terms of preserving people's rights. But Brian, is there anybody who is willing to connect with us on that from that organization?
I don't honestly know why they didn't answer me. I won't say that they didn't answer me. I talked to their director, who referred me to another person that I've had dealings with before on our studies from CLTA, and I made sure that they got the memos. And then I followed up to ask if I would be attending the meeting and didn't get an answer.
Okay.
I suspect if we take another break on this, it won't be a disaster. This could wait another year, which is what would happen probably, because it would be hard to fit it into a bill for 2022 if we don't approve it until January. But no harm in that. There's no urgency here, and I could press again. My experience with the Land Title Association is that they do not like revocable transfer on death deeds, and at every stage where they have expressed an opinion, they have expressed opposition. And they may feel like they have sort of exhausted their repertoire with the commission, because they have provided feedback before, but it has never moved the needle. And so I don't know what to expect. I do think it would be nice to get confirmation that the analysis is correct and that we're not missing anything.
I'd really like that. I think that the problem, not the problem, but I think that, a lot of people are moving towards probate avoidance tools. And so, to me, it feels incumbent that we really make sure we get it right, because of that, because many people don't have, people are still handwriting wills and signing, which of course we know are valid in California, but there needs to be, I don't know how I see Commissioner Creel has his hand up, and I would love to hear from other people, but I feel a fair reluctance to adopt something today, but so I'll let other people chime in.
David.
I think I agree with Jane and John Anderson that, so my general preference would be if the intent is a certain thing, I would rather see that certain thing in the text to make the intent clear, so that nobody has to review our comments, right, look up the fact that our comments are persuasive, think to look at our I'd rather it's in the text of the statute. That's just as a general preference. I could go either way on whether we did it now versus waiting. I can definitely see Jane's concern. I would rather have heard from a stakeholder here, but if they're ghosting us, I would kind of take that as a sign that, I could see them saying, well, they're going to do this and we don't want to weigh in because that would look like we're supporting it, which we don't. So maybe they feel like they've taken their best shot at this and we're going to do what we're going to do, and they're kind of out. On the analysis being correct, it does occur to me that the Ledge Council is going to look at this, obviously. So somebody's always going to check our work. So if that's the holdup, I would say let's go ahead and do it, and Ledge Council will catch any errors if any there are, and I doubt there are. My other general preference is, if we see a problem, let's solve it. But I definitely see Jane's concern. So if the consensus is to wait, that won't hurt my feelings.
Well, January is not an end all be all for making amendments to bills for 2022 anyway.
Huh.
So, that there's an introduction of new bills deadline, but they can always amend those bills and add content to it if they decide. And I think I was thinking the same thing, David, about Ledge Council in terms of validating Brian's analysis. Could be a resource there as well. So
yeah, I would say that it's unfortunate that Kara's not here today, but my sense is that when Ledge Council is in bill drafting mode, they're doing more of a scrivener's function.
Yeah.
I don't think they're doing a dive on the merits of every bill they draft.
I would concur with that.
So
So-
I would be skeptical if they would offer an opinion on whether my underlying analysis is correct, or they wouldn't. We'd have to ask for it, that would be pretty atypical.
Brian, question on that. So, I mean, is what we're looking for from the stakeholder, checking our work to make sure that the analysis is correct, or is it more that they would weigh in on whether the fix we're proposing is the best way forward?
The former, really. What I would like is the experts in this field, in this practice area, to tell us if we're missing anything.
And you don't feel like silence is assent here?
Yeah, it's a hard read. It's hard for me to read. I mean, the other thing is we could proceed, and if we get pushed back in the legislature, which is where it would surface, we could always retreat to like a stock co-op exception position. If we're convinced that there was a missed implication in the broader fix, but
Is it? Sorry.
I'm willing to entertain the possibility that there's something that I'm missing. And I think the most likely thing is that my analysis hinges on this sense that there is this totality of possible circumstances that is split down the middle between off-record interests are ascertainable, off-record interests are not ascertainable. And on the one hand, it's carved out of the policy. On the other hand, the purchaser has no liability, so there's nothing to indemnify, right? And that's a very legal analysis. And I'm not sure that I understand the practical implications, because as an insurer, if the insured says, I don't think it was ascertainable, right? I don't think I did some reasonable inquiry and I didn't find it, and I don't think I should have found it. And I'm now being sued by the person who holds the interest because they want to enforce it. Defend me, insurer. If it's not ascertainable, then it's not carved out by your exception. And that's what I'm asserting, is that it's not ascertainable. And therefore, it's within the coverage. Defend me against this claim. And so there might be, at the margins of those two legal cases, there might be uncertainty that could result in litigation, and that insurers might be called upon to pay for. And I just don't know in practice how that works, or how large that possibility is, how large the costs are. I don't know.
Do you feel like if we make a tentative recommendation, whatever that happens to be, that will encourage stakeholder activity?
Yeah, but we're past the tentative recommendation stage. We did that already. We're proposing a final recommendation, which ought to be even more urgent for them. The other point I want to add to what I just said, though, is, let's say that's possibility, that there's friction at the margins where there's uncertainty that could result in defense costs. I don't see why that would be any more likely or any worse for property transferred by RTOD deed than property transferred by any other means. Like, if I'm just selling my property and the purchaser wants title insurance and they're not being covered for non-ascertainable off-record interests, and they could wind up in the same situation. I bought the property, now somebody says, hey, I had a off-record contractual purchase option, and I want to enforce that against that property. It would still come down to whether it was ascertainable or not.
Well, the title insurer can always just exclude it. So that could be an exclusion from the title insurance. If there are any unascertainable interests, they're not covered. So it basically makes it own risk. You have to do your own diligence, and if you screw it up and miss something, it's not covered by your title insurance.
Yeah,
The insurers may not care, is what I'm saying.
But I think that's exactly was exactly my point, is that we need to know if they care or not. Because I hear you completely, Commissioner Creel, I do. And I think that's the thing. We just need that little bit, I'm looking at this. I mean, I'll admit I tend to look at things from a public policy standpoint a lot of times. And so what I'm thinking is, okay, ascertainable, readily ascertainable. What does that mean? That is actually fairly subjective. Do you have a person who is not able to marshal the resources to research something like this that has been, this thing's been transferred to them? They can't defend an action because I just, I know I'm kind of like extrapolating here, and pardon me for that, but I know TextCom is really good about getting back to us, and I'd at least like to hear what they had to say, because real world application, I mean, we can talk about whether an insurer will cover something or not, or policy exclusions, but that's just really at a level that it's important, it's integral to the process, but I'm wondering what that actually means in real time. Do you know what
No,
I'm trying to say?
yeah, I completely agree with you. Because what I suspect will happen is title insurers will just either revise their policies or it'll become standard practice to say, anything that's, reasonably ascertainable, it's just not covered because, so the parties are going to rely on the title insurers to look at the public records and, do all that kind of obvious diligence stuff, which they do, but they're not just going to, walk down the street with a big sign saying, hey, does anybody have any readily ascertainable interest about this? They're just, they're going to look at the public records. If they don't find anything, that's as far as they're going to go. And then I suspect if this becomes law, they're pretty quickly going to start a practice or put something in their policies that excludes anything that's not part of a public record. So if there's a handshake deal or something holographic, that's on the transaction, the parties of the transaction, and it's not covered.
Well, that's exactly right. So the burden is shifted. It's a question of where the burden lies then. And then, again, I mean, the same argument. So, I don't want to debate this issue forever. I know we need to move on.
I think you're right, Jane.
What anybody else has to say.
Yeah, my instinct is I'd rather, if there's some, as Brian said, if there's some nuance that exists out there in the real world that we're just not aware of, I'd rather find that out now rather than in front of some committee where the legislature says, oh, you guys, didn't really understand what you were doing when you proposed this. So my instinct would be to at least give the title insurers, to the January meeting to weigh in on it, and we can then, amend the bill with whatever we come up with, as opposed to it being part of a newly introduced bill.
Yeah, and Rich, you're actually speaking exactly to my second concern, which was that, try really hard to be very meticulous about all of these things. And sure, we could introduce it in an amendment, but I don't want to look sloppy.
Right.
I should say that at the last meeting and in my conversations with John Anderson since from TextCom, he emphasized that they are estate lawyers, not real property conveyance lawyers. And so, he thought that CLTA would be the better authority to answer questions about practice. And I will lean on them a little bit more than I have. I'll give them a call and just really emphasize that we need them to let us know whether we're going down a wrong path and why.
Do we have any practitioners in like the real estate or transactional section of the bar that we could reach out to that might be of help on this?
Yeah, I could talk to somebody. I could try and find a contact at the real property section. That's not a bad idea. That's a good idea.
Yeah, Barbara?
Well, we also, Ed Regalia from Miller Star and Regalia used to be a member of the commission. And maybe there's somebody at that firm who might be helpful.
Yeah.
I mean, they're real property experts, and they, I think, feel a certain kinship to the commission based on Mr. Regalia's past membership.
Yeah, Ed sadly is deceased, so I couldn't talk to him personally, but I could see if there's somebody in the firm who could talk to me about it. That's also a good
Good
idea.
idea. Good idea.
So let me ask you a nuts and bolts question. It seems to me like the commission is coalescing around a preference to postpone this until we have better information. How do you want me to present the materials at the next meeting? I don't really want to write another cycle of these memos. Is it all right if I just write a very brief memo that maybe refers back to these
Yes.
materials?
Yes.
Okay.
That'd be great. And then if we got it, of course, if we had any communications from any stakeholders, and just
Right.
to stick it with that, and then I think we
Yeah.
have definitely enough to be able to assess it.
I agree. Yeah, that makes sense.
Okay.
So we'll defer this till January and see if we can shake the
tree.
tree and get some of those.
Let me, if you don't mind, let me just do a roll call on it because it's
Okay.
something I'd really like to put in the minutes
Yep.
as a decision. So Commissioner Carrillo,
Carrillo, aye.
Commissioner Cubas,
Aye.
Commissioner King, Commissioner McAllister,
Aye.
Commissioner Simpson.
Aye.
Thank you. That's that item done.
Great. Thank you, Brian. And next we have the first of the trial court restructuring matters. Barbara.
Okay, so this has to do with the comments on the tentative recommendation for the study of statutes made obsolete by trial court restructuring part 8. That's the work that focused mostly on judicial benefits and on statutes relating to representation and indemnification of trial courts and trial court personnel. The commission approved that tentative recommendation in late September. The due date for comments was December 3rd. We made extensive efforts to obtain comments on the tentative recommendation, but there have not been any comments. And reasons for that are discussed to some extent in the memo. The question at this point is how does the commission want to proceed given the lack of any further comments? Is there anything that the commission would still like the staff to do to try and solicit further comments? I'm not optimistic that further efforts will be successful because I think we've really gone to the sources that are most likely to weigh in on this. And I should mention that I had sent a reminder message to the folks at the Judicial Council very recently. They have let me informally know that there has been review of the tentative recommendation within the Judicial Council. I don't know specifically what people or parts of the organization, but that they do not plan to submit any formal comments. So the first question raised in the memo is do you want me to try and do anything further to elicit comments on the tentative recommendation?
Any members have suggestions or other individuals or organizations? I think Barbara's outreach seemed pretty complete to me, but you guys may know that world better than I do.
No, I think you did everything that really could have been done at this point, Barbara. So I think the delay, it just makes you do extra work that's really, I don't know that's going to accomplish anything.
Okay.
Anybody else? Okay. Okay, so we're comfortable with the outreach.
Then unless the commission thinks otherwise, what I would do is to prepare a draft of a final recommendation for the January meeting. And there were just 2 questions raised in the memo that I wanted to get guidance on before preparing that draft. The first one relates to the amendment of Government Code Section 990.2, which relates to giving the Judicial Council, rather than the counties, authority to obtain insurance for liability and defense of trial court personnel in trial courts. And there's a note in the tentative recommendation that suggests, that raises the question of, does the Judicial Council really need this authority? Is there some other source that already provides it? Would it be more appropriate to repeal the statute rather than amending it to give the council authority instead of the counties? And because the commission hasn't received any input that establishes that the authority would be unnecessary, I think the safe course is to stick with the approach in the tentative recommendation, which seems to be unobjectionable. At least we sure haven't heard any concerns. And so I just want to check and make sure that that's okay with the commission.
Any question or comment? That was, I mean, your the direction you were going, Barbara, was my instinct as well. I don't think that there's a downside to explicitly providing that authority. It might be redundant with something else, but in the event someone thought they didn't have the authority, making it explicit seemed to make sense to me. Anyone else?
Okay, so we'll draft that, the recommendation that way, which is the way it's already drafted anyway. And then the second point is sort of in reverse posture. The tentative recommendation proposes to repeal Government Code Section 26524, which makes it mandatory for the local district attorney to provide representation and defense of trial court personnel under certain circumstances. There is a note with that proposed repeal that explains that the section appears to have been superseded by Government Code Section 811.9, which gives the Judicial Council the responsibility of providing for representation and defense of trial courts and trial court personnel. And the council is to do that through the county council, the attorney general, or other council. And then the note asks, well, are there circumstances in which the Judicial Council might still want to use a district attorney for purposes of providing representation? And the note points out that if so, then maybe it would be better to amend this statute rather than to propose to repeal it. And again, we have not had any concerns expressed about the proposed repeal. And I think at this point, it's pretty clear that there's been an opportunity for people, particularly the Judicial Council, to pipe up if there were concerns. So, my recommendation is to stick with what the commission has in the tentative recommendation and just go forward with the proposed repeal for purposes of draft recommendation.
So, Barbara, my question was, I'm looking at page 3 on your first memo, and it says Judicial Council provides representation or defense of trial court personnel, quote, through county council, attorney general, or other council. I mean, couldn't that include the DA anyway?
It perhaps that language is broad enough to include the DA, even if they want it. You're right. I mean, that might be sufficient.
It also occurs to me that could be the insurance contracted counsel that's referred to in the first point. So if the Judicial Council negotiates, some sort of, statewide insurance defense coverage policy for all judicial officers, to me, that falls into that or other council catch-all.
Yeah, I mean, they routinely hire as I understand it, like law firms to represent them in particular matters. And so, it's not just the county council or the attorney general who are representing the judicial council. But I guess the reason for posing the question about amending the statute with respect to district attorneys is that there are certain details provided, I think, if I remember right, provided within that provision that maybe would be helpful. Let me take a quick look at that. No, actually, it doesn't provide any detail. So
So I'm assuming that the repeal then, given what 811.9 says, the repeal seems to be fine.
I think that makes a lot of sense to me.
Any question, comment, suggestions by members? Is there anyone of the audience who wants to weigh in on this? I don't know the names, so.
Not seeing anyone with their hands up.
Yeah, I didn't either. Okay. Okay.
Okay,
Then
well, I think
keep this
that
one up.
pretty much covers this memo, and we'll bring back a draft recommendation for consideration in January.
Okay, is there do we need to take an action on this, or you'll bring it back next time for us to act on?
I guess, maybe it'd be good to have a formal vote on proceeding with the draft as discussed, which basically sticks with the tentative recommendation as it was sent out.
I'll make that motion.
Okay. Is there a
Okay.
second?
I'll second it.
Jane? Okay.
So Commissioner Carrillo,
Right. Aye.
Commissioner Kubas,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
and Commissioner Simpson.
Aye.
Okay, well, that takes care of that memo.
Okay, and it looks like you're still up there, Barbara.
Yep, and the second memo has to do with the drug asset forfeiture proceedings. At the November meeting, the commission directed the staff to prepare a draft of a tentative recommendation to basically along the lines suggested by attorney Mark Lomax, who is here. He's one of the attendees of the meeting, so maybe we should enable him to speak.
Mr. Lomax, anything you'd like to share with the group?
Yes.
Right.
I have very brief comments. I just want to say Ms. Gale has done an excellent job of summarizing the issues and the goals of the proposed amendment. And I'd like to reemphasize, and I know this has been said several times, these proposed amendments are not substantive. They are declarative of existing law. It just clarifies that how a drug asset forfeiture proceeding is classified as a limited or unlimited case. But I would like to make one point. As has been noted, the drug asset forfeitures are not without their critics, and they've been accused of being abused by prosecutors and law enforcement agencies. But I think for the critics of drug asset forfeiture proceedings, these amendments could be viewed as indirectly beneficial for a person who seeks to challenge a forfeiture. This is because limits on discovery and attacks on pleadings in limited cases may make a challenge of a drug asset forfeiture proceeding more difficult in a limited case. So to the extent that these amendments clarify that these drug asset forfeiture proceedings are unlimited, and to the extent that they thereby prevent misclassification of a drug asset forfeiture proceeding as limited, they would benefit someone challenging, because someone challenging in an unlimited civil case has more tools available to attack the proceeding. So although these are not, as I said, these are not substantive changes, for those who criticize drug asset forfeiture proceedings, this amendment, I think, indirectly benefits those who are trying to challenge drug asset forfeiture proceedings.
Thank you, Mr. Lomax. I get what you're saying. I'm not sure that's going to be a game changer for them, but David.
I just wanted to make a couple of points. I think that Mr. Lomax's two chief points about this being a non-substantive change and about no one, especially this commission, taking a policy position on the merits of drug asset forfeiture. Those points are incorporated in the memo on pages 10 and 11. So I agree with those points, and they are in the memo as they should be. And I also just wanted to thank Mr. Lomax for bringing this to us. This is a meritorious issue. It's right in our lane, and this is the kind of problem I love solving.
Thank you.
Barbara.
Okay, well, so at the November meeting, the commission also directed the staff to formally solicit input from the chair of the committee on revision of the penal code regarding whether the commission should go forward with the project, and then to report back to the commission about what the committee chair said. And Brian was the one who had the actual conversation with the chair of the committee, Mike Romano. And so Brian's going to share with you what the committee chair said.
Yeah, I think it breaks down into three main points. First, they aren't concerned that the commission working on this would infringe on sort of their portfolio.
Did you say are or not?
Are not. I meant to say are not. Second, they are not concerned that the commission working on this would create problems for them. But third, we were advised that this area is politically fraught, and that we might run into difficulties, even with a narrow technical fix, that this is an area where there's not a lot of trust between the different interest groups. And we might face a bit of an uphill battle convincing people that that there's no poison pill in here and that we're not secretly doing something disadvantageous. And on a related point, and this third point is more sort of about like how things would play out. I suggested that, it's possible if amongst those who don't like asset forfeiture as a matter of policy, they might not like the implication that the legislature is reaffirming it by tweaking it rather than reforming its substance. And the chair of the committee agreed with me that was a possibility, that sort of the implied endorsement by imperfecting it rather than paring it back. So that was the gist of it.
So reenacting it with minor changes is the same as reenacting it.
Yeah, it's sort of an affirmation, an endorsement. And we can put in a disclaimer that we're not doing that.
But, right.
But the last point is more about sort of like political reality rather than the first two, which are about whether or not we'd be causing trouble for the committee. And the sense I have is that we would not be causing trouble for the committee. They'd be okay with us doing it. But
if anybody's going to do it, they'd rather have us than them.
Probably, yeah.
Okay. Barbara, you had your hand up.
Well, I just wanted to say that, just to some extent, I already tried to include language in the draft that is a disclaimer, and tried to include language that would disclaim not only that the commission is, taking a position on the merits of the drug asset forfeiture statute, but also that by enacting the proposed reform, that the legislature would not be in any way, sort of endorsing the current statutes or condemning them. And, whether that language is sufficient to, address concerns that might come up, I don't know. And if anybody can think of ways to improve it, that'd be great too. And I think Mr. Lomax has his hand up.
Oh,
I would just like to add that since this is being done under the rubric of trial court unification cleanup, I think that's helpful. I mean, I agree that there will be people who object to any changes in the existing law other than repeal. But I think that the way it is couched under the trial court unification statutory cleanup, I think that is beneficial and helpful in identifying the objective of the amendments.
That's a good point. I mean, the commission is directed by the legislature to clean up the codes in response to trial court restructuring. And this is part of what we may think is necessary to properly fulfill that role.
And that study is intended to be non-substantive.
Yes.
and so the functionally, we are saying, but for trial court restructuring and elimination of what do you call them? The other courts.
Muni.
Muni courts, this wouldn't be an issue, but now the muni courts are no longer there. This is an issue, and here's how you would address it.
And the issue is solely an issue of potential confusion. And our remedy would be clarification. Is that right, Barbara?
Clarification along the lines that, it's totally non-substantive. It perpetuates the pre-unification status quo and does nothing more.
Any comments or observations or questions or suggestions from members as to how to proceed?
Do we need to move this?
Well, yes, if you want to proceed with a tentative recommendation, you will have to vote to approve the draft as a tentative recommendation with or without revisions. And I guess, at this point, one question then is, does anybody have any suggested revisions of the draft that's attached to the memo?
I do not, and if pending any thoughts from my fellow commissioners, I'm prepared to move the tentative recommendation.
I agree. I don't have any other thoughts either. And I think you're making it extremely clear that this is a non-substantive recommendation. And we will hear, obviously, once the tentative recommendation goes out.
Right. Any other commissioners want to make comments or observations about this? Hearing none, seeing none. David, yours was a motion to approve as proposed.
I so move.
And we got two firsts and.
I second Jane's motion.
A second, yeah.
Oh, good.
Okay.
Okay.
And go ahead and call the roll, Barbara.
All right, Commissioner Correa,
Aye.
Commissioner Kubas,
Aye.
Commissioner King. Aye. Commissioner McAllister
Aye.
and Commissioner Simpson.
Aye.
Okay, well, that completes that item.
Okay.
Thank you.
Great. Thank you, Barbara. I think Kristen's up next with the toxic substances statutes.
All right. Good morning, commissioners.
Good morning.
I have two memos before you today, and both of these relate to the same topic. Back in February of 2021, the commission approved two recommendations, one to recodify a part of the health and safety code related to hazardous substances, chapter 6.8, and then to make the conforming revisions necessary to implement those changes. Since the commission approved those recommendations, we've had a bunch of 2021 legislation. So before we seek legislative introduction of the commission's recommendations, we simply need to make the updates necessary to reflect what happened in the legislative season this year. So the first memo, Memo 2021-65, presents the changes to Chapter 6.8. There were 4. 2 of those are very minor. They're discussed in footnote 4 of the memo. We're just going to adjust our recommendation to reflect a cross-reference update for the Public Records Act and then a minor terminology change. The more complicated item in the first memo is there were actually 2 new sections added to Chapter 6.8. And in the memo, we discuss where to place those. And then the attached draft shows proposed legislation to essentially slot those new sections into the recodification. It describes where we decided to place them and sort of the choices about where they would fit within the scheme. I don't know if the commission has any questions or wants to discuss those items. I'm happy to answer any questions, but I think, the memo kind of walks through the decisions that were made and, the language of the sections we preserved. And that's
Okay.
that.
Any members want to make comments or observations about the proposed relocation of those enacted sections last year? Hearing none, seeing none. Okay.
The one item that I will note is there was a minor correction that we proposed. There was a redundant cross-reference in one of the new sections, and it seems pretty clear what the correct cross-reference should be. I do want to mention that I ran that by DTSC staff. They didn't raise any concerns. Unfortunately, they weren't able to be here today, but they looked at the materials and didn't have any concerns to raise. So.
Got it. Thank you. Thank you.
So with that, that goes through the first memo, and there's 2 decisions for the commission, and you can take them together or separately, depending on how you want to proceed. The first question is simply, does the commission approve sort of incorporation of the proposed legislation that's presented with that memo into the bill draft that would implement the commission's recommendations? And then the second question is, does the commission want to update its recommendations because they have not yet been printed to include this material?
My instinct would be to take it all in one, in one vote. I don't think we need to bifurcate that question because they're part and parcel of each other. So is there so you're looking for a motion?
Yes, a motion to approve the draft, and then it sounds like incorporating it into the recommendation as well.
So moved.
We have a motion by Carrillo, second by somebody,
I'll second it.
Jane.
All right. And
Please
I will
continue.
call the roll. Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
and Commissioner Simpson.
Aye.
All right, and then moving on, the second memo is actually a bit simpler because it's the conforming revisions. So memorandum 2021-66 just discusses the changes to the sections that cross-refer to the material that we propose to recodify. The changes were very straightforward in this case. It's simply updating cross-references. In some cases, sections that we had already proposed amending, we just needed to update their language. In other cases, there were some new cross-references added to existing sections or a new section that had a cross-reference. Really nothing out of the ordinary here. I will mention that one of the things that we did come across is some of the sections that are in this draft actually contain cross-references to the California Public Records Act. We made an effort this year to update those, but those changes were chaptered out. I know that there's a separate effort to get those changes enacted, but I've also incorporated them into this draft so that we don't run into a conflict with ourselves. And I think that's about it. The one the one very minor item I will note is there was a section where there appeared to be a missing word. So we propose simply adding back in the word that seemed to be missing. That's section Health and Safety Code 25205.2. And so it's just specifying that a fee is paid to a particular agency. But otherwise, we did include some notes where the cross-reference updates might be a little hard to understand. And it was essentially prepared just like the prior draft. And if there's any questions, I'm happy to take those, but.
Okay, questions or comments from commission members? Any of the attendees here for this item?
Seeing no hands.
No hands, okay. A quick question, Kristen, did you say there may be more than one bill that's going to reenact sections that were chaptered out?
Well, I think for the California Public Records Act, and Barbara could correct me, the updates that were chaptered out, we will be trying to, there's Barbara coming back, trying to reintroduce those to get those updates made.
Okay.
In this case, if we're pursuing legislation to enact the toxics material, we'll have that bill as well. So we would have two bills that would be amending the same section,
And we will have to coordinate.
Okay, that's what I was going to say. yeah.
They're two commission bills, so I don't anticipate any problems coordinating.
Got it. Okay. Want to make sure we didn't chapter ourselves out. Not that it's never been done before. Okay. Is there a motion to approve the content in the second memo as proposed?
So moved.
and can I clarify, is that also to incorporate that into the commission's recommendation?
Yes.
Great.
Yes. It's been moved and seconded. Jane seconded. Can you call the roll?
All right, Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner King, Commissioner McAllister,
Aye.
and Commissioner Simpson.
Aye.
All right, thank you very much. That's all I've got for today. I appreciate it.
Okay, thank you. And last but not least, Steve.
Hello again. So we have two memoranda here for Fish and Game. 2021-57 is the first one. As you know, we have been engaging in a process, somewhat involved process, in which we've been presenting to you proposed revisions that were proposed by the Commission in a tentative recommendation some years ago. And we are now attempting to excise those that would be appropriate to be made to the existing Fish and Game Code. And in the memos, we have typically been presenting these proposed revisions in different categories. The first category is the commenters, meaning the Department of Fish and Wildlife and the Fish and Game Commission have agreed this is an appropriate revision. The second category is don't make the revision at all. The third category is what this memorandum is about. These are proposed revisions in which the comments we've received from the two agencies have indicated support in general for the proposed revision, but there's not been any language that's been presented. And so what we've done is we've identified those items and have started engaging in conversation with the agencies to the extent we can, and in particular, Department of Fish and Wildlife. I've had various meetings and we've talked about the sort of the principle of the revision and whether that would be appropriate. The commenters had previously indicated it wouldn't cause any substantive change, but we weren't sure whether there was clear approval, and it was a matter that we needed to discuss. So this memorandum concerns only those provisions. This will be the first of that type of memorandum in which we have talked about these proposed revisions in principle, and a representative from Department of Fish and Wildlife has said, yes, that's fine, we're good with it, but they still have not seen draft language. So this memorandum presents draft language of these provisions in that category, in which previously there was an indication that the provision would not cause a substantive change, and now we are proposing language to implement the change.
Okay.
So this is, as we've done with the other memorandum, we're asking for this to be a consent item. In other words, all the proposed revisions that you have in this memorandum, we will be asking for a provisional approval as collectively rather than going individually. But certainly an opportunity is available for anyone to ask any questions, make any comments, including anyone who may be in the audience from Fish and Wildlife or otherwise. Questions or comments about any of the
Questions or
proposed
comments from commission members? Hearing none, seeing none. Same thing, questions or comments from any of the in the audience? Okay. Seeing none, hearing none. I just want to point out that subdivision F of 4004 says you can't use thoracic compression to kill a trapped mammal. Thoracic compression is a bear hug. What if it's a bear? No, I'm just kidding. Never mind.
Well,
Wait, just to show you, I was, you know,
it
actually,
would be a very tight hug, I imagine.
it would be a tight hug.
You
Okay,
have it right,
I got it. All right.
but that's good to know. We have a number of things like that in this code, actually, where there's sort of words that have different meanings. And
Listen to me.
okay,
All right. So you're looking now for a motion to approve
provisionally approved.
provisionally approve as proposed.
Yes.
I'll move.
Jane moves. Is there a second?
Second.
David seconds.
Okay, thank you.
Okay, call the roll.
Sure, I'll go in alphabetical order this time. Commissioner Carrillo,
Aye.
Commissioner Kubas,
Aye.
Commissioner King, Commissioner McAllister,
Aye.
and Commissioner Simpson.
Aye.
All right, thank you very much. The second memorandum is 2021-58. This is just an informational memorandum. Again, the process that we've been engaging in, again, one of the categories is revisions that have been approved, at least in the tentative recommendation, by commenting agencies. And so we collect them in a draft and we continue to add to them. Eventually, this will be the legislation, the proposed legislation that we will be presenting to you as part of an approval of a recommendation, a draft recommendation. And then there's an appendix as well that sort of keeps track of the where the other provisions are, so to speak, and in terms of their review. So there's no decisions to be made about that.
Okay, so this is kind of a review of where we are at this point in time.
That's correct.
Okay.
Does anyone have any questions or comments?
Questions or comments about where we are on bear hugs and fish traps?
All right, then. Thank you
All
very
right.
much.
Thank you.
That's all that we need for that
Steve. Okay.
study for now.
Now that looks like the end of the agenda. Brian, anything else we need to consider now?
No, we're good.
Any other questions or comments for the good of the order?
Oh, it's just great to see you back, Kristen.
I agree. Yep.
Everyone have a happy holiday.
You
Yes.
too.
Yes.
Thanks.
Happy
Thank
holidays.
you all for
Happy
all your hard work.
Thank you very much, guys.
Thank you so much
Appreciate
for everybody, and for Jane for making the time to be here too. We very much appreciate
Oh,
that.
no problem, no problem. I'm sorry about the kerfluffle.
Not a problem. Not a problem.
All right,
Okay.
take care, guys.
Well, thank you all, and wishing everybody a happy holidays and a happy new year. And we will see you all again in January, but still Zooming, right?
Still zooming
Still
for
zooming.
January. Yep.
All right.
Okay, sounds great.
All right.
Take care.
Great time, everybody.
You too.
Thank you
Thanks,
Bye-bye.
everyone.
Bye, everybody.
Happy holidays and happy new year.